Okay, thanks everyone for coming. We're very fortunate today to have with us Jonathan Goldstein um, to talk to us about red flag laws, the good, the bad, and the ugly, and importantly, probably how not to let it get ugly.
Mhm.
Jonathan is a founding partner at Goldstein Law Partners. He brings almost 25 years of experience to the area of relevant for us firearms law, but also election law and entrepreneurial law. Um, he's a certified pistol instructor. He regularly speaks about firearms law and firearms safety. He's received multiple awards in the area for his service to the space. Um, his legal expertise has really been recognized nationally, and he's well known in the area. He most notably, recently anyway, he received a citation by Justice Alito in Justice Alito's concurrence in New York State Rifle and Pistol Association versus Bruin. In his spare time, when he's not working on firearms law and running his law practice, he likes to fly. He's a licensed commercial pilot. Um, so he'll be speaking to us today, and then we'll have some Q&A at the end. If you'd like to submit a question, please do so using Zoom's Q&A feature. I'll then read the questions aloud as they come in, and then Jonathan will answer them for us. So with that, thank you all for coming, and I'll turn it over to Jonathan.
Thanks, George. Very grateful for the opportunity to be here with you all today. You're all very brave to sign up for a firearms law CLE on a Friday in the summertime. So kudos to everyone who's joined us. Um, uh, if anybody has questions as we go along, please feel free to put them in the chat. I'll try to address them sort of as we go, if it makes the most sense, if they're topical for a particular issue that emerges on a slide. I will also say, as George mentioned, I'm involved with a number of firearms related organizations. I was recently elected to the board of the National Rifle Association, and I'm also a trustee of the NRA's Civil Rights Defense Fund. But I should be very clear that today I'm here in my individual capacity, not speaking on behalf of any organization. So why don't we get into it? So let's talk a little bit about red flag laws. What are these things, right? Red flag, red flag laws. We got to, it has some connotation of stopping people, right? What are we doing here? Well, as of 2020, about 18 states had these things. As of 2025, you got three more, and then Washington, D.C. and the Virgin Islands added them. And they come by a bunch of different names, right? In Delaware, they call them this lethal violence protective order. In Hawaii, it's gun violence protective order. They call them ERPOs in a lot of other states, extreme risk protection orders. ERFPO in New Mexico, firearm restraining order, all these different names. GVROs in California and New Jersey. And then in Connecticut, they just call them a risk warrant. So Indiana was the newest state to add one to the mix, and they went with something a little more scientific, right? Proceedings for the seizure and retention of a firearm. Sounds very serious. But what are they? What's the alleged purpose of these ERPO laws? I'm going to call them ERPO laws, red flag laws, for today's purposes, right? In Hawaii, the legislature made some findings of fact when they put this law into effect. And they say the idea is to reduce gun deaths and injuries, yada, yada, right? That's what they say they're for. Okay. They also talk about that they're there for reducing suicide. But one of the things we're going to find as we dig in on this topic is that you would actually approach this in a very different way if that were really something you were concerned about. So, presumably, in most cases, the purpose of these things, they say, is to reduce gun deaths and injuries. Well, how do they propose to do that? Every one of these things comes with some kind of a triggering or reporting or initiating mechanism, right? There's some kickoff set of facts, some kickoff, gating procedure, and then it's sort of off to the races. So that's something that all these have in common across all these states and territories that have put them in place. In almost every case, they begin ex parte, right? That's lawyer talk for unfairly, right? It begins where I get to come into the court and tell them my tales of woe and my sob story about how dangerous you are and why you should be stripped of these of these constitutional rights in a big old hurry without any word from you, right? That's what the ex parte commencement entails. And in almost every state, I believe it's actually in every state, these things begin ex parte. What is the burden of proof in these things? Well, it's not criminal, right? They point out all the time, no, no, these are not criminal proceedings. These are civil proceedings. So you get preponderance or clear and convincing, right? What's the difference? Well, George will tell you it's a huge difference, right? It's a matter of whether the judge woke up and was merely dyspeptic or whether he had a real ulcer forming in his stomach. That's the difference between preponderance or clear and convincing, right? It's one of these non scientific, I think it's a little more, I think it's a little less. But in either case, what we know importantly for our purposes is that it's not a criminal standard. It is some kind of lesser civil standard, either 51% or whatever clear and convincing is 60%, right? No one can ever tell you, but it's not criminal. So it's a lower burden of proof. These things happen at tremendously high velocity. And when you think about the allegations that are made to kick off a red flag process, right? Typically, they say it's because somebody is in some sort of extreme circumstance, right? So they're in extremis, they're having a problem, they're having a mental breakdown, they're having some kind of anger management issue. And so, what do we decide to do? Well, we decide to bum rush them ex parte, but then we do it really fast. So what could possibly go wrong, right? It's less than criminal standard. It happens really fast, and I get to come in and get it started without giving you any ability to do anything about it at first. Then, as if all that were not enough, the burden winds up shifting onto the subject of the order, right? I come in and I say, "Oh my God, he's very ill and he said mean things and whatever the kickoff mechanism is, and we'll talk about that in a slide or two." And then suddenly, this person who is in extremis, who had very limited knowledge of what was coming at him, in a very high velocity way, has to start gathering evidence to prove that he's not the thing you say he is. Due process varies quite greatly, right? One of the things you're hearing about all the time now in the immigration context and in the efforts to shut down, all the work that President Trump is implementing, for better or for worse, right? I'm not going to tell you where I sit on all that, but certainly there is a lawfare effort to shut him down and to find judges that will point to things like due process. Well, for all the due process that we give to illegal aliens today, for all the due process we give to people that are accused of all manner of crimes and sundry offenses. In the context of these red flag discussions, there's a very limited due process that is afforded to most people that are what I'll call the victims or the subject of these things. And we'll talk about that again in a few slides. In many cases, there are warrantless searches or expedited warrants that are done to effectuate it, right? So once we've begun the process ex parte, once we have done this in a very, very fast way, once we have convinced a judge under a lower burden of standard, once we have done so without affording the accused of much due process, then we go get a warrant and begin fishing around for where are all those very bad guns that we are trying to keep him from having at this moment. And that creates a whole host of problems that we will again talk about in a few slides. There are criminal penalties in most cases for violating these, right? The subject and third parties. So the subject of the order can be subject to criminal penalties, right? The victim of the order, and third parties who assist someone in potentially violating one of these orders could also be subject to criminal penalties. So we can initiate it with a less than criminal standard, but boy, oh boy, you do something wrong, suddenly we find our sea legs to start hitting people with criminal standards. There are, in most cases, penalties for lying to obtain an order. I will tell you, it is my experience that these penalties are sought mainly in the breach, right? They are very, very rarely sought. So I think even our ideological opponents who think these are a great idea, to have all these different, lowered burdens and high velocity and all that, even they understood that we probably ought to put something in there that if somebody lies to get one of these, It's got criminal penalties, but I can tell you that they are very rarely enforced. And then in terms of legal assistance, this is a very disorienting process for a person who's subject to it. We've already identified this person as someone who's struggling potentially or probably with some kind of mental health issue. And yet only one state, Colorado, offers legal assistance for people that are subject to these. As you know, it's a civil proceeding, so there's no Gideon rights, right? Unlike a criminal proceeding, there's no Gideon rights. And, our ideological opponents who are trying to get these things enacted, um, talk about how they're doing everybody a favor by not having a criminal standard. And yet by not having a criminal standard, it leaves the people who are subject to these orders bereft of proper legal support. And as you can imagine, particularly if you've looked at the supplemental materials that I provided as preparation for the CLE, these things are very, very complicated. Even judges, in many cases, don't understand how these things work. Okay. So who initiates an ERPO in most states? Well, in many cases, it's law enforcement, right? A police officer or even a prosecutor in some cases can kick these off. That seems to be a factor common in every state. In some states, it can be mental health professionals. Is it a mental health professional who you see? So, for example, if I'm seeing a therapist and that therapist knows that I have guns and decides that, well, he or she is going to place their views or their politics ahead of what I might suggest is their ethical obligations to me to keep my confidences, can they kick it off? Or is it that somebody else has to bring this to some kind of public mental health professional? In Pennsylvania, we have a county mental health officer who's involved in some decisions about whether a person should be committed for examination. Is it a model like that where a public mental health professional gets involved? Is it a family member? In some states, that family member definition is read very narrowly. A spouse, maybe children. In some states, it's read very broadly. It's not just spouses and children, it's ex-spouses, it's lovers, cousins, people with whom you have a sexual relationship of some sort, or maybe someone with whom you've had a child, irrespective of whether you were married to that person or not. So how a family member who can kick one of these off is defined changes from state to state. In some states, a school official can kick it off, right? The data we have, show that is a population that is, certainly at the university level, much more of a monoculture than it ever has been. And that those people in many cases take a dim view of firearms. Well, you combine that with, the ability to kick off a process like this, and you can put a gun owner into a pretty bad spot pretty quickly just because they're enrolled in a school program, right? Here's the definition from Hawaii for what a family or household member means, right? Any spouse or reciprocal beneficiary, whatever that means, former spouse or formal reciprocal beneficiary, whatever that means, a person with whom you have a child, a parent, a child, a person related by consanguinity, adoption, jointly residing. I mean, this is a breathtakingly large definition of the pool of people who could become a threat to your ability to continue to own and possess your firearms, right? A family or household member, in another context, could just be a person who's an adult roommate or a cohabitant. Hawaii also includes coworkers, educators, and law enforcement. So it's a very broad base of people. In Florida and Indiana, it's law enforcement only, a much narrower population. In the slide deck, I include this chart that gives you a sense of who can kick it off. States like New Mexico and Rhode Island, law enforcement only. States like Hawaii, much broader base of people. So if you're in one of these states, you need to govern yourself accordingly. And if you're in one of the states where these laws have not yet been passed, this is a very important piece of the discussion. To the extent one of these is going to get enacted in your state, you need to be looking very carefully at who can petition to kick off a process like this. Okay. So what has to be alleged to kick one of these off? Well, in many cases, you have to allege some kind of risk to self, right? That the person is a danger to himself. What does it mean to be a danger to himself? Well, I'll know it when I see it, is the standard in many cases, right? There is some kind of objective standard that is in many cases laid out or elucidated in statute. But in most cases, particularly with a preponderance or clear and convincing standard, it's basically an eyeball call from a judge about whether this person is a risk to themselves. What about risk to others? Certainly that is a component in many states, right? So it's not just that you're potentially engaged in self-harm, but that maybe you're going to harm somebody else, right? When did that happen? When were you a risk to yourself or others? Does it have to be in the last 24 hours? Does it have to be in the last week, the last month? What happens if you were potentially a risk to someone else 3 or 4 months ago and it's hung over them and they're troubled by it? And 3 or 4 months later, they decide to come forward and say, well, 3 or 4 months ago, that guy was he was really sort of weird with me. He was a threat to me. Um, does that mean you're still a threat today and we should extinguish, gun rights? So all of these are questions that come up on the public policy side, and each state sets these dials a little differently. Is violence an element? Right? In some states, there has to be what we would call an act in furtherance, some kind of violent act. In some states, mere what I'll call weirdness is enough. The guy creeped me out, and I know he's got guns. We better get those guns away from him because he's creepy, right? These are very, very poorly designed standards in many cases, and you really need to keep an eye on this if your state is talking about enacting these things, right? There are states where this is the standard, preponderance of and weirdness and risk to others that comes from 12 or 24 months ago. That is a recipe for having people's core constitutional rights extinguished without basis. Is an overt act required, right? So is it merely that I showed a propensity for violence? I like boxing, or I have martial arts training, or I yell a lot, or I get red-faced, or maybe I have trouble controlling my temper, or did I have to punch a wall next to your head, or throw something at you, right? So whether the overt act is required is one of the elements that changes from state to state. Are utterances enough, right? I'm going to kill you. I'm going to hurt you. Get out of here before I do something bad. That sort of thing. Um, um, Animal cruelty is a basis in some states, right? Some mental health studies have shown a high correlation between people who engage in animal cruelty and people who have a high preponderance for violence against people, right? In many cases, folks will say that animal cruelty is a gateway behavior or gateway crime for people who may later hurt humans. So in some states, they have hooked that and made that a basis for an allegation for an ERPO. Is illegal use of drugs a basis? In some states, in fact, it is. So if I'm an illegal user of drugs and I happen to be a firearms owner, and maybe utterances are enough, maybe just weirdness is enough, now I could find myself not having access to my firearms. One of the things you should be thinking about is, well, you know, could you replace the word firearm with some other constitutional right? Voting rights, the ability to go into a synagogue. Hey, sorry, you made illegal use of drugs and you're kind of weird. You creep people out. I'm afraid you can't go into a religious facility until we get some more information on you. And we're going to bar you, I'm afraid, for a year, to give us some time to really understand who you are. I mean, it would be absurd, right? No one would stand for that. So we're going to talk about that again in another slide or two. Is it an element of the allegation that you deserve an ERPO against you that you acquired or attempted to acquire a firearm? Indeed, in some states it is. The fact that you attempted to acquire a firearm or that you have firearms is a factor in whether an ERPO should attach to you. The reckless use or display of a firearm. What constitutes that, right? So, for example, in Pennsylvania, where I am, open carry of a firearm is lawful as long as you're not in a vehicle. Now, the definition of vehicle is very broad, but let's assume you're on foot. Well, if you're on foot with a firearm on your hip and you're up in Forest or Elk County, two of our least densely populated counties, that wouldn't cause anyone to bat an eye. But if you were to be walking in a near-in suburb to Philadelphia or Pittsburgh with a gun on your hip, lawfully on your hip, someone might describe that as reckless, or that you're displaying a firearm and trying to be provocative around it, right? Now, we have no such crime in Pennsylvania. There's no brandishing crime. But here again, we're not talking about a criminal standard. We're talking about a preponderance standard. I know it when I see it, more likely than not. So this could become an element, even though there's nothing criminal or troubling about it from a criminal standpoint. What about related proceedings? The data we have show that there are a significant percentage of times where firearms related restrictions are weaponized in the context of child custody and divorce. They can also be weaponized in the context of mere civil suits, right? And for those of you who want some of these citations from me, I have another whole deck that I use when I'm talking about firearms public policy. I can provide you with some of these citations. Just email me. My contact information is available either from George or at the end of the whole deck. I put up a slide with my contact info. Happy to share that information. So, how long does an ERPO last? Well, in Colorado, the ex parte one can be 14 days, and a final order can be renewable for periods up to a year. Now, let's go back to the prior slide for a moment where I said these are weaponized in the context of other proceedings. Can anybody imagine a circumstance, maybe a child custody dispute, an acrimonious divorce, a breakup, where a person would go out and seek an ERPO against a spouse, maybe a few days before hunting season starts? Maybe a few days before a firearms competition were to start? Well, if you can't conceive of it, you're not paying attention, because I'm aware of cases like that in a number of different contexts. It absolutely is weaponized in purposes like that. 14 days is an eternity. What about a person who carries a firearm for work, right? A person who's a security guard. If he has to call his employer and say, I can't carry my gun for 14 days, does he keep his job? In many cases, he won't, right? What about a person who faces a mortal threat, right? A person who carries a lot of cash or owns a jewelry store or a check cashing store, or perhaps just lives in a troubled neighborhood, right? Stripping that person of a firearm for 14 days on an ex parte basis is an awfully big deal. Think about what the world looked like if you lived in Los Angeles 14 days ago and what transpired in that intervening 14 days. Boy, you sure would be pretty upset if you had acquired a firearm, trained with it regularly, needed it in the context of those riots, and suddenly were stripped of it on an ex parte basis. Connecticut, 14 days ex parte. A final one requires a petition and a hearing to end it. So it goes on indefinitely, an ERPO, right? Imagine a person who were experiencing some form of mental breakdown or found himself in extreme circumstances, and we said, well, sorry, you can't vote until we have a hearing and a petition to see if you're really fit to get that voting right back. You're a pretty dangerous guy. No one would stand for it. In California, the temporaries can be up to 21 days, ex partes can be up to 21 days, and a final goes for up to a year, renewable. And in New Jersey, here again, we have this petition and hearing required to end. It's breathtaking. We're extinguishing a core constitutional right, and you have to petition and hearing to get it back. Who pays for that? Who bears that cost? Who bears that burden? Who bears the cost of the expert that invariably will need to appear on your behalf at that hearing? Who bears the cost of the attorney who will have to appear at that hearing on your behalf, right? Thousands and thousands and thousands of dollars to get your rights back, just to go back to the status quo ante. And in New Jersey and in Connecticut, it continues indefinitely until you scratch up all the money to hire those experts and those lawyers. Very troubling. Speaking of trouble, we got trouble, big trouble right here in River City. For those of you who like shows the way I do, right? What are the problems? Well, it's Philip Dick's pre-crime, right? Philip Dick, as many of you may or may not know, is a science fiction author. And he had this idea of pre-crime, right? We are not concerned with people who've committed a crime here. We're concerned with people who might commit an act of violence, might commit a crime, might threaten someone else, might use that gun for an illegal purpose, might hurt themselves or others. So it's pre-crime, and that's very troubling. And you would like to believe very infirm from a constitutional standpoint. Sadly, it is not infirm. In many states, in at least the 21 jurisdictions where these things exist, this has been thought to be okay. It's the extinguishment of a core constitutional right under a less than criminal standard. Very troubling. And here are three cases that you can go pull where the firearm right has been reduced to the second class right that Justice Thomas warned about in Friedman v. Highland Park, right? He talks all the time in his writings about how the Second Amendment is not some second class right, right? It is the Second Amendment in the Bill of Rights. The founders told you how important they thought it was. It was right ahead of the Third Amendment about quartering soldiers and the Fourth Amendment about being free from unreasonable searches and having a warrant requirement. This was a big deal to these folks. And when you get a court like this one in Reddington, where a fellow was subjected to an ERPO, and they held that, quote, the statute's impairment of the owner's right to bear arms based on a finding of dangerousness of owner was not of substantial magnitude. Pardon me? Seems to me that the extinguishment of a core constitutional right enumerated in the Bill of Rights would be an awfully big deal. Again, here, substitute voting rights. What happened if I said, well, until we get you straightened out, until we know whether you've got a problem, with your ability to keep your mental health in order, Mr. Goldstein, we're going to quarter some soldiers in your house just to make sure that, nothing untoward occurs. People would lose their minds. But with regard to gun rights in particular, not so. The other problem, one of the many other problems, is this really results in the criminalization of mental health, right? Remember what we talked about earlier, a high velocity mechanism with a less than criminal standard where the burden shifts onto the victim or the subject of the order, right? And he's got to sort of defend his actions towards others. And if he doesn't defend those actions adequately, if he doesn't defend why he wanted to buy a firearm, why maybe he's a casual user of marijuana, any of the other factors that I listed on the prior page, he basically suffers the same result as you would suffer with a criminal conviction just for having a mental health issue. Couple that with this notion of pre-crime, we're in a pretty troubling place constitutionally, in my view. Police don't like it. You go ask the police if they like kicking down doors of known gun owners who are having a mental health episode. You won't find a police officer in the country who says they relish the thought of doing that. And yet, this is what the legislatures, egged on by the anti-gun folks that get these things enacted, are asking the police to do. It is very, very dangerous for police. And we're putting them in a really risky spot. And the question is whether there are better ways to do this. And I have some solutions at the back end of this. It's not all bleakness all the way around. There's very little enforcement, as I mentioned, for abuse of initiation, right? We know the penalties are in the statutes, but it just doesn't happen. And the power to initiate these things and the effect that they have on the gun owner results in a real asymmetric power dynamic where the burden shifts quite squarely onto the subject of the ERPO. So let's talk specifically about what we saw in Pennsylvania when they tried to enact this some time ago in HB 2227. The prime sponsor was an embattled moderate suburban Philadelphia Republican. He was open to dialogue, but he felt like he had to do something, to save his keister. He was embattled.
I'll interrupt for a second. We have a relevant question
Sure,
that you asked. We do as you go, so I'll read that to you.
sure.
Uh, Question: are there any specific states that build in more severe penalties for false accusations? Also, do any states build in protections against damage to confiscated property, which, when talking about firearms, can be a significant financial investment?
Yeah. So the second part of the question first. Are there protections for damage to firearms? We did write that into our statute here in Pennsylvania. And if you email me separately and you're looking for good language around that, we did write it. We then augmented that a number of years ago with a section that I actually authored myself that dealt with the process for what the police had to do when a firearm was either abandoned or purported to be abandoned, and we put some structure around what they had to do before just destroying firearms. But yes, in Pennsylvania, here at a minimum, they are responsible for a diminution in value, certainly in the PFA context. So if they take firearms from you for a protection from abuse order, one of the things that they used to do was they would test fire firearms. Well, you'd have a collection of firearms where the value in the firearm was that it had never been fired, and they say, "Well, we have to fire it to make sure that it doesn't match anything in the FBI's database." I mean, so we did get some protection around that. And then George, the first part of the question, I'm sorry, I missed it.
Yeah. Are there any specific states that build in more severe penalties for false accusations?
So, king for a day, one of the things that I would do if I were a district attorney, I would have one person in my office, an assistant district attorney, who all that person did was perjury. I would have a sort of perjury beat in my district attorney's office because I believe that the lying, whether it be overt, straight up, bald faced lying, or whether it be the kind of exaggerating that we all as lawyers see in the context of civil litigation these days, has gotten well out of hand. So, in most states, you have a pretty robust perjury statute. Most of these initiating documents must be made on a sworn basis. But even where they're not made on a sworn basis, here in Pennsylvania, we have a statute allowing for criminal charges for unsworn falsifications. And I would just encourage you to look to those statutes for use in this context. The other thing I suppose you could do would be, a 1983 suit, because if the person is using this sort of state-sponsored mechanism to extinguish or conspire with others to extinguish my core constitutional rights, that would be an interesting thing worth exploring as well, particularly if your initiator were a person of means. Okay. So in Pennsylvania, we're back to our embattled suburban Republican who needed to do this to show that the overwhelmingly blue district where he was elected, might want to send him back there because he could work both sides of the aisle. So what does he do? He puts forward a bill, but numbers and tags and definitions mean a lot. What did the bill do? Well, it modified Title 18 under our statutes. That's where our criminal statutes are. So when you see these efforts begin in your state, one of the first things you should look at is where are they sticking this, right? If it's about mental health, why aren't we starting in our mental health statutes? Why aren't we starting with our existing mental health procedures? Here in Pennsylvania, we got a sense of where his supporters or the people that had egged him on to do this thought this whole thing was supposed to sit, where the genesis of it was because they were modifying our criminal statutes. Red flag on the red flag law, so to speak. The problem we had here in Pennsylvania, again, one of the many problems, is that this thing was to create a new, different, third, not just second, but third high velocity mechanism where civil rights could be administratively restricted. Here, I'll direct you to the documents that I shared in anticipation of this CLE today, where we already had two mechanisms to restrict rights. And now they want a third one. The third one had different definitions, different commencement mechanisms, a different standard of law, different procedures, different affidavit requirements, different relinquishment requirements, and different procedures for the return of the firearm and different penalties than the first two. So your state goes to do something like this. One of the first stops, one of the first places you may want to stop off and have a conversation is with your judiciary. You think your judiciary wants to have people coming into their courtroom with three different high velocity mechanisms, all of which have different standards of law, different procedures, different affidavit requirements. I mean, it's enough to drive you to drink, right? So enlisting the personnel who are going to be expected to administer these procedures is a great way to bring folks that might ordinarily be a neutral player with regard to something like this. It's a great way to bring those folks onto the playing field and say, hey guys, you ready to administer this thing? Because people are going to be knocking on your doors in the middle of the night looking for these ERPOs. And It's going to work different than a protection from abuse order is, and it's going to work different from the other mechanisms we have. We need your help getting this thing under control. The other problem is with the three mechanisms that we had in Pennsylvania, two and the proposed one, so that would be the third, is that they could all be used simultaneously or in rapid sequence. So if you think about them as potentially being weaponized, now what you have is a guy who is, potentially subject to one of these, maybe two of these, maybe three of these all at once, all with different procedures, all with different requirements. And here I'll give you an anecdotal example. I have a guy who was a client at one point, and he was married and had a girlfriend on the side. And the girlfriend on the side got upset when he realized that, he was not going to leave his wife and marry her. And they wind up getting into it, right? So they don't hit each other. There's no physical violence, but she decides that she fears him now, right? She's going to take out a PFA. It was pretextual. We later proved, I think, certainly beyond a preponderance standard, that it was pretextual. But she went and swore out a PFA against him. Oh, did I mention that before she swore out the PFA, she had him picked up for mental commitment for an examination, right? So here's a guy she's having an affair with. They get into a tangle. She calls the police and says, he's, suicidal or sad or whatever in the context of our relationship that's breaking down. She has him picked up and taken off for an eval. He's hospitalized for 5 days. While he's hospitalized, she swears out a protection from abuse order against him. Well, our statute in Pennsylvania, where a person gets taken in for mental examination, allows for 60 days for you to relinquish your firearms. The PFA statute, however, allows for only 24 hours. So when he first is 302'd, when he's first taken in for a mental health exam, I start gathering up all of his firearms and farming them out to his friends who have safe capacity, storage capacity to store these firearms. He then gets out of the 302, out of the mental health exam, and gets served with the PFA. And the sheriff in that county says, okay, now you need to get all these firearms back, and I need them all back in one place within 24 hours. And I said, we can't get them back. People are at work. People are all over the place. The sheriff says, Goldstein, if you don't get all those firearms back to your office within 24 hours, I'm going to come kick your door in and seize them all. Okay? So that's with just two firearms and mental health mechanisms working. Now they want to add a third one. And when you start to talk through anecdotes like that, and you start to talk through the weaponization of these procedures like that, it very quickly becomes clear that this can become extremely problematic. And indeed, if you think about my door getting kicked in, it could become dangerous even for third parties. It's a bad idea to have more than one of these mechanisms in your state. And that's worth talking about with your legislature if these sorts of things start to get proposed. So we'll get specific, right? What did they hear us on? Well, it used to be the case that these ex parte orders would come into effect when issued. Now, I challenged our legislature to identify for me another context in which an ex parte order comes into effect when it is issued, not when it is served, when it is issued. Can you think of any other place, any other mechanism under the law where an ex parte order comes into effect when issued before it's served on the party who is the subject of it? We could not find one. So when we raised that problem, they changed the statute that service had to be made. You couldn't just have this thing come into effect, because what would happen is you would have a person seek, for example, a protection from abuse order over a weekend, or when they knew that their husband or partner was traveling. And so the guy would be traveling. He had 24 hours to turn his guns into the police. He'd be out of town. He'd come back into town 36 or 48 hours later. And the partner who swore out the PFA would sic the police on him. And now he's in violation of the order because he only had 24 hours to turn it in. Service was a critical aspect to that. They heard us on that, and now service is required as part of the negotiation. Spoiler alert, they never got this law passed into this bill passed into law, but they recognized that service was important. And we did modify our PFA statute to require service. Time to prepare. So the way our PFA statute used to work was that a person would swear out a PFA. Typically, it's woman swearing it out, man who's the subject of it. So that's the framework I'm going to use just to keep things moving today for the CLE. The wife would swear it out. The husband would become subject to it. Um, our statutes and our case law required a hearing within 10 days on the PFA. Maybe the guy was out of town for a week. He comes into town, shows up at the hearing, and says, I need more time to prepare. I don't even know what this is about. What's going on? And the way our case law read was that the judge could say to him, the fact that you're here at this hearing means you knew about it with enough time to prepare, put on your case. So he's going to have a core constitutional right extinguished. He came looking for more time to prepare and is told your presence here indicates you had enough time, put your case on. So we changed our PFA statute in Pennsylvania to allow people to have a right to a continuance and a minimum amount of time to prepare for these sorts of hearings. We required that same change in this bill when they wanted to enact ERPO in PA. A right to counsel, right? Is that embedded in this? I mean, a core constitutional right is going to be extinguished. It's going to have all kinds of other consequences. Imagine a person who's a police officer. Imagine a person who's a security guard. Imagine a person who's a bail bondsman or a prison guard, right? Livelihoods can be affected by these ERPOs, right? A soldier subject to this could be bounced out of the military, right? A person with a security clearance. One of the cases we ran across was a guy who, in the context of his job as an intelligence analyst, would never carry a firearm. But it was a requirement of the clearance he had that he be able to carry a firearm. And when a PFA got sworn out against him, he lost his high-level intelligence job and indeed could not then go into the private sector because the intelligence clearance was revoked, which is something that people normally keep as they move into the private sector to monetize their government clearances. So, should a right to counsel attach? It was something we discussed in the context of that bill. Again, they modified our criminal statutes here. And in Pennsylvania, we have a peculiar misdemeanor offense. We have what's called an M1, a first degree misdemeanor. M1s in Pennsylvania are subject to penalties up to 5 years in jail. Well, the problem is for Pennsylvanians specifically, or people charged with M1s in Pennsylvania, under federal law dealing with firearms, a misdemeanor offense punishable by more than 2 years is considered a felony under federal law for firearms purposes. So a person who is convicted of a first degree misdemeanor in Pennsylvania winds up being federally prohibited. We talked that through with the bill's sponsors and downgraded many of the criminal penalties that they embedded in this bill from M1s down to M2s, because an M2 in Pennsylvania is punishable by up to, but not more than, up to 2 years, which meant that an M2 does not meet the federal definition of felony. But that was a conversation we had to have about a peculiar aspect of Pennsylvania law. One of the things we wanted was the ability to award civil damages in the ERPO context, right? So getting civil damages we thought was a fair mechanism for people lying about the ERPO. I lose my job, I lose my property, I lose my livelihood, I can't go hunting, I can't take my kids shooting, I can't take my kids hunting, I get hurt because I have a gun for self-defense, and during the pendency of a falsely sworn ERPO, I'm injured. We thought that should be cognizable. And so we had a discussion about whether civil damages should be awardable. And then the other thing we wanted to prevent was door kicking, right? The language we put in the bill prevented door kicking, right? And it had to come with a request. It had to come not at the barrel of a gun at first. A person had to have an opportunity to relinquish in peace before we moved to violence. And that was a very important part of the mechanism. Okay. Problematic definitions. We had a family or household member definition that was capacious and that was very problematic in that respect, right? A former sexual or intimate partner, there was no time limit on that, right? What if I ran into my college girlfriend on the street from 30 years ago, and she took a look at me and said, "Oh my God, I'm scared of that guy. He was mean to me 30 years ago." Did that give the person the ability to then swear out an ERPO against me? The answer was potentially. She could be a person considered to be eligible to swear it out. Now, whether she could succeed or not remains unclear. But we wanted to tighten up that pool of people. The other issue is the definition of law enforcement officer who was eligible was a law enforcement officer from another state or political subdivision. So you're telling me that I'm here in PA and I'm gaming on a platform and I get into shit talking with somebody in another state and they call a police in New Mexico and a New Mexico police officer could come initiate an ERPO against me here, right? We thought that definition was too capacious and wanted to see it trimmed down, right? Firearms licenses, they wanted all firearms licenses relinquished or seized in the context of an ERPO. Well, here's a news flash for those of you who don't do a lot of hunting, principally folks in the non-gun community. You can hunt without a firearm, right? You can hunt with primitive weapons in some states, right? An atlatl, a blowgun in some states, but certainly in almost every state, I think in every state, you can hunt with a bow and arrow. A black powder firearm is not a firearm under federal law. It is in Pennsylvania, but under federal law. So requiring somebody to relinquish a hunting license shows a lack of familiarity with what's going on. It's a change. It's a requirement written by a person who's not familiar with this and just wants to attack and hurt and hem in a gun owner. And again, if you have people that are on the fence in your state about these sorts of things and you want to bring them over to your side, bring them onto the playing field, to shut down an effort to pass ERPO, this is the kind of overreach that you can point to. Similarly, they had a definition of hearing officer that was too wide, too broad. Masters, court magistrates, these are not people who are judges. They wanted these things to be able to be sworn out in front of bail commissioners and all kinds of minor members of our judiciary. Well, if my rights are going to be extinguished, I think that ought to happen in front of a judge. And we were able to prevail upon them that a narrower definition of the sort of judicial officer who could hear these complaints was beneficial. Similarly, they had a definition of firearm that they wanted to include. Well, here's the problem with firearm. We have a thing called the Uniform Firearms Act in Pennsylvania. Now, Jonathan, surely in the Uniform Firearms Act, there is a uniform definition of firearm, right? Well, only if you think all these different places where there are definitions of firearm have the same definition. Spoiler alert, they don't. We have 15 or 18 different definitions of firearm in Pennsylvania. I've listed some of them, there are others. It's bananas. And I've long asked for them to be harmonized, and everybody has a reason why they love their one little particular definition. Work in progress. Structural problems. And again, we're closing in on the end of our CLE here, so I'll make sure we get through this and land the plane on time. It allows evidence up to 12 months old. Well, you're trying to get an emergency ex parte order, high velocity. This guy is an absolute danger to himself. Well, Mr. Goldstein, tell me why he's a danger. Oh, it's easy, Your Honor. Last May, 11 and a half months ago, he was really, really mean to his girlfriend. Okay, right? Is that really what we are going to rely on for an emergency ex parte order to strip a constitutional right 3 days before hunting season? What about 3 days before an election? We can't let this guy vote. He was mean to his girlfriend 11 months ago. Now, I don't mean to minimize domestic violence, and I'm sure I'll get some feedback like that, as I occasionally do. We're trying to illustrate a point here, right? Domestic violence is serious. We can't allow for it. We have to help people that are subject to it. But here today, what we're focused on is how problematic some of these procedures are, And you can see that if we were to substitute voting or some other right, people would be up in arms. Assuming, by the way, they were not subject to an ERPO and had their arms, they would be up in arms. To terminate an ERPO, the person subjected to it had the burden to prove that it should be terminated. That's very problematic. Failing to relinquish firearms was an M2, right? But it was still criminal penalties, up to 2 years in prison for an M2 for failing to relinquish your firearms for a person who is allegedly in a mental health crisis. Why are we criminalizing the behavior of people that are in mental health crisis? That is the wrong approach. If one of the key takeaways that you take away from this presentation today is that, I will have succeeded. If it's a mental health issue, keep it in a mental health context. Why are we talking about crimes? Bash, 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 bash. It doesn't always have to be stick. It can be carrot. Let's talk about that. If law enforcement can initiate an ERPO, what's to use it pretextually to go fishing for unrelinquished firearms and then find other contraband, right? If I'm a cop and I want into that guy's house real bad and I can't meet a criminal standard to get a warrant, could I find somebody who says, well, he was in an intimate relationship with me, I dated him, he creeped me out, and now I go get an ERPO warrant and I'm in his house and I'm looking for other contraband? Structural problems, very problematic. So here I ask, why are we working in their framework? You got to draft these things like your civil rights depend on it, because they do. If you start with a white piece of paper, you got to get the public policy right. You got to talk to gun owners generally. You got to talk to some gun owners who have accessed the mental health system in your state. You got to talk to people that are interested in the system but that don't own guns. They can be our friends. They can be our allies. Fundamental fairness, analogizing to voting rights and religious rights is powerful. Analogizing to jury trials. Sorry, you were an extremist and you threatened your girlfriend. No jury trials for you. These notions resonate with the non-gun owning public. The polity broadly. There are people out there that have other civil rights concerns who you can access to build consensus around getting some of these protections built into ERPO and chasing out some of its worst elements. You got to build coalitions. The mental health community doesn't want to see mental health issues criminalized. They are a valuable ally for us. I have a call next week with somebody who just wrote to me and said, oh my God, I just found out what it means that when people are 302'd in Pennsylvania, 302 is our statute for taking people in for mental health examinations, that they lose their firearms rights. Can you tell me more about this? Yes, I'll spend an hour with you on the phone educating you. Law enforcement doesn't want to kick doors. They can help us chase some of the worst aspects of this out. Family law and mental health lawyers have a stake in this. Those sections of the bar should be drawn into the conversation. The courts, as I mentioned earlier, they don't want another high velocity emergency mechanism. And then you would think like the ACLU and groups like this would care about things like this. It is a civil right. Due process is a civil right. As goes the gun owner, so goes the criminal defendant down the road. And some of the branches of the ACLU understand this. What does it mean practically? Well, if it's about people, right, gun owners or others who are in crisis, it should begin and end in the mental health system, not the criminal justice system. How do we do that? We get the proper incentives for people to get the help they need without permanently losing a core civil right, right? We entice them to come in for treatment. How do we do that? We leverage existing mechanisms, right? We have mental health practitioners. We have statutes in Pennsylvania and in other states to help people get the help they need when they're having a mental health crisis. Why must we invent these new mechanisms that are sadistically and totemically focused on guns? Why must we fetishize the gun itself? Let's look at our existing statutes and see what we've got available to us to help these folks. Are there things we can do to bolster them? You bet your butt there are, right? We can narrow the range of people who can initiate. It should be a person who's got some context for the mental health, a parent, a child, a spouse, right? Or maybe it's a physician or a mental health practitioner. Maybe it's a police officer. Departments now are becoming more enlightened and are training police officers in these mental health issues, right? A state police officer in Pennsylvania, they cover a lot of the rural areas in PA. They have this mental health training. But it has to start in the context of mental health. You can't just go after the gun owner absent the mental health counseling. You can't just say, we're taking your guns because you're having mental health problems. Well, you haven't finished the sentence. We're taking your guns because you're having mental health problems, and we want you to get the help you need for the mental health crisis. So what do? If you're ordering a relinquishment, let's use the existing mechanisms. I rewrote the relinquishment mechanism in PA a number of years ago as part of a statutory rewrite. Let's not reinvent the wheel. Let's use that mechanism. And then the other thing that I said was that we ought to be putting supervised outpatient counseling from a licensed mental health professional along with this. If we really care about this gun owner as a human being, as a person, as a citizen, as a member of our polity, let's get that person the help they need, right? Let's make sure that upon discharge from this process, the person gets his firearms rights back cleanly, easily, without having to go through a hearing where he has to hire lawyers and professionals, right? Let's make sure that a mental health practitioner is breaking the difficult news to the person. Let's make sure that it's not a police officer kicking a door down. Let's make sure that it's better for the person in crisis as a result. It's better for the police, and it gets the incentives rights, and it limits the weaponization of these processes. It provides for a more level playing field by having a right to a speedy hearing with good due process protections. Court appointed counsel, the one state that got it right, treats this like a criminal issue and gives people the right to appointed counsel. People should have the right to preserve evidence, to compel the attendance of witnesses, to know the method by which witnesses may be compelled. These are all changes we got to our PFA statute some time ago. Know that these things can come back to them, how they can relinquish, right? And there should be a way back, automatic return of firearms. At the expiration, the firearms shall be returned. And the best innovation, the one that I proposed, was if these folks who wanted to take guns were serious, they would put a source of funding together to make sure that people could access mental health services, even if they couldn't afford it. Makes them put their money where their mouth is. If you're stuck in a bad framework, negotiate for some of these protections. Call me, call NRA. We've got best practices around these. If you're in a better geography, use our white sheet of paper approach. Due process is a primary consideration. If it's about people in crisis, make the conversation about helping people in crisis and don't indulge in the pretextual gun fetishism that the other side wants to do. If you need help, you can call me. I'm happy to help you, and I'm happy to stay on and answer questions for folks that have questions beyond. Thank you for your time and attention today.
Okay, thank you, Jonathan. So I have two comments here and then one question.
Sure.
That'll take us a little bit over, but I believe actually at least the Wyoming State Bar will give credit in at least quarter-hour increments, hopefully. So here's the first comment from one of our colleagues in Brazil. Uh, just quoting here. In Brazil, Decree number 11.615/2023 grants authorities broad powers to suspend firearm licenses and seize weapons based merely on visible signs of psychological unfitness, even if the person holds a valid psychological report. Anyone can report these signs, triggering immediate seizure without prior expert evaluation. To contest the decision, the individual must pay for a new exam by a panel of 3 psychologists. If deemed unfit, they must surrender the weapon, transfer it, or request compensation, subject to budget limits. Public officials are exempt from these rules, leaving accountability to their own institutions. The decree raises concerns about due process, unequal treatment, and potential abuse.
In the famous words of Al Gore, I agree. It does raise, fundamental fairness concerns. I'm sorry to hear that that's happening to you in Brazil. You have new leadership down there, and maybe it's time for you guys to push for a more robust Second Amendment-like set of rights down there. But that is a tragic state of affairs. And for those of you who are in the U.S., that is precisely the reason why the Heller decision, the Bruin decision, and the decisions that look back to the founding period for whether these sorts of restrictions can be enacted were so important to us. So for our colleague in Brazil, I'm sorry that you faced that. I hope you can find your way to a better place over time.
Okay, thank you. Another comment rather than question, to quote our attendee. In Illinois, my former state, we have a second, excuse me, in Illinois, we have a second restriction of firearms rights that can happen with or without the ERPO, which we call Firearm Restraining Order. The second restriction is revocation of the FOID card, Firearm Owner ID card, for those who aren't familiar with it, which is required by state law for firearm ownership or possession. If the temporary FRO is dismissed by the judge, the subject of the FRO still has to go before the seven-member FOID card review board for an appeal to get the FOID card back and must follow all of their procedures to request and meet the requirements for their appeal process. The FRO judge cannot order the FOID card restored as part of the FRO dismissal because the statute says the FOID card review board has to hear the case. So you may win the FRO battle and still lose the appeal to the FOID board.
So this is why places like Illinois and New Jersey that have these Kafkaesque procedures around gun ownership and firearms ID cards and all this sort of thing are going to be some of the next litigation frontiers, I think, um, for some of the gun groups nationally, right? Those kinds of procedures are Kafkaesque, right? And they are designed specifically to frustrate gun ownership. Think about substituting the restoration of voting rights in a mechanism like that, or your religious rights, and people would be over the bend on that sort of thing. So I believe that those sorts of mechanisms are unconstitutional ultimately, and I believe that they are the sorts of things that deserve to be struck down over time. And I'm sorry for those of you in Illinois who face that. You're welcome to move to the free state of Pennsylvania or some of the freer states of South Carolina or Florida or anywhere in the South. But that's a tough state of affairs. Um, uh, George, I can read this next one from Alicia if you would like, because I can
Oh,
answer her question pretty quickly. Yeah.
yeah, please do. If you
So
could, I'm super.
yeah, we have a comment from a person named Alicia who has created a grassroots 501(c)(4) for gun rights in Colorado. She's pointing out how there's a lot of abuse going on with red flag laws and others, and she wants help fighting it. Alicia, send me an email and I'll get you connected with somebody at NRA who can talk to you a little bit about maybe how we might be able to help. No commitments, no promises, but they certainly would be willing to have a conversation with you, maybe get you hooked up with your state affiliate for NRA, and maybe there's something to be done there. And then finally, the fourth comment or question was, what is the optimal language you would use for a statute such that it effectively covers situations where it's appropriate but is not susceptible to the abuses and oversights you've outlined? I don't like red flag laws generally, but I could help you with some language if you have a state where you're getting ready to implement ERPO. NRA has model language that it's willing to tolerate. Due process protections are part and parcel of that, are an absolute must. And there's some other language depending on the contours of what's being proposed. You're always welcome to email me if you have a state where these things are starting to move, these bills are starting to move, and I'd be delighted to assist in any way. So, George, does that conclude our questions and comments at this point?
It does, Jonathan. Thank you very much for joining us. The video will be up on our website in the video library within a week or so. And we also have a webinar coming up next month where I will be interviewed by Joe Greenlee, who's another firearms attorney. He'll be interviewing me about some of the scholarship I've done. So thank you all for attending, and we hope to see you next time at our next.
Thanks again, everyone.
Bye bye.